The hearing will come to order. I thank all of our witnesses for being here. We are in the middle of a vote sequence over in the Senate, and so you'll see people appear and disappear as they have to come from and return for votes. I thank Senator Kennedy for allowing us to get underway as he is on his way over here, and I will take the time to do a little bit of housekeeping, particularly with respect to hearing exhibits. With consent, I will ask for the Reuters article, Special Report Inside J&J's Secret Plan to Cap Litigation Payouts to Cancer Victims, to be made an exhibit in this hearing. I will, with consent, get this Wall Street Journal article behind me, also entered as an exhibit. I have two constituent letters from John J. Erickson, Jr. of Newport, Rhode Island, whose late wife, Geraldine, passed away after a difficult battle against ovarian cancer, and John Tessone of Narragansett, Rhode Island, who has been diagnosed with mesothelioma and has undergone a major lung surgery. I will ask that both of those letters be made a part of the record of this hearing. We also have a letter of support from 7 bankruptcy professors submitted to our subcommittee for this hearing. The professors are Professors Elias, Ayotte, Blocklieb, Dick, Markel, Rasmussen, and Yadav, and their letter will be made part of the record. And finally, there is a brief in the United States Bankruptcy Court for the District of New Jersey, filed by Dean Erwin Chemerinsky of the University of California, Berkeley School of Law, indeed Dean of that School of Law. And I will make his amicus curiae brief a part of the record here. I'll do some opening remarks. When he gets here, Senator Kennedy will then provide opening remarks. If Senator Durbin gets here first, he's the chairman of the full committee, and he may seek to offer some opening remarks. So we'll have 3 rounds of opening remarks with any luck. And then I'll introduce the panel, and you can proceed with your testimony, and then we'll go on to questions. I will be pretty rigorous about the 5-minute rule. I know you've all put a lot of work into your statements. They can be made a part of the record, so we have the full benefit of your full statement. But senators who come to a hearing are eager to ask questions and engage with the panel, and moving to that quickly is a good thing for a chairman to do. And so I will be a strict policeman of the 5-minute rule. We are here to address a novel and rather troubling circumstance that is emerging in bankruptcy law. Imagine that a big corporation wreaks serious harm on you and your family. You sue for damages to cover hospital bills or to care for a family member. But when you do, you discover that your claim against the company, a company that is out there operating, apparently thriving in the marketplace, your claim is somehow in bankruptcy court. It may not be heard for months or years, and it may never be paid. Sadly, this situation is not imaginary. The so-called Texas two-step has mired tens of thousands of claims in bankruptcy proceedings. It's bankruptcy's aim to grant honest but unfortunate debtors a fresh start while doing the utmost to make creditors whole. But in recent years, large corporations on solid financial footing have found a bankruptcy trick to shirk responsibility for hurting Americans. Here's how it works. First, a corporation with claims against it from people that have been harmed transforms into a Texas corporate entity. Second, that new entity exploits a Texas law allowing something called a divisive merger, splitting the corporation into two corporations. Company 1 is saddled with the claims. Company 2 takes the corporate assets. The company saddled with the claims then files for bankruptcy, perhaps in North Carolina, where the Fourth Circuit makes it nearly impossible for victims to have the company's filing dismissed for bad faith. Victims harmed by the corporation are left in bankruptcy proceedings that can take years to resolve, condemned to receive only a fraction of what they're owed. Meanwhile, the company with the corporate assets continues business as usual, shed of the claims. That's the Texas two-step. Although, to be fair, the same thing can potentially be done under Delaware law. The originator of this move is perhaps the most prolific industrial polluter in American history, Koch Industries. In 2017, it used the Texas two-step to dump its subsidiaries' asbestos liabilities. Victims are still tied up in the bankruptcy process, as are asbestos claimants in ensuing copycat cases. Johnson & Johnson, one of the biggest and richest companies in the world, last year faced over 38,000 lawsuits alleging that its talc-based baby powder contained asbestos and caused ovarian cancer and mesothelioma. Johnson & Johnson followed the Koch Industries model and hatched a shell company that took on the talc liability and filed for bankruptcy. Johnson & Johnson now seeks a stay of all those claims pending bankruptcy proceedings. This move presents four big concerns. First, it violates the fundamental principle of bankruptcy that a company is forgiven its debts, but it must offer up all its assets to creditors. Then it gets a fresh start. The Texas two-step separates the assets from the liabilities in violation of this basic principle. Second, it denies people their day in court. The civil jury has been a bastion of individual rights throughout our history, allowing people a vital check on the most powerful forces arrayed against them. The Texas two-step denies victims a jury of their peers, defeating the Seventh Amendment in our Bill of Rights. Third, it encourages forum shopping. Johnson & Johnson had no particular reason to file for bankruptcy in North Carolina. In fact, Johnson & Johnson's Texan liability shell only existed for 2 days before it filed bankruptcy. Outcomes in court should not be determined by strategic forum shopping. Finally, the Texas two-step mires victims in protracted proceedings, robbing them of precious time. Asbestos victims can die of mesothelioma and other types of cancers before their claims are heard. That is a blot on our legal system. So far, this trick has hit asbestos victims, but once the two-step strategy catches on, it could deprive all sorts of victims of the compensation they're due and undermine the integrity of other creditor-debtor relationships. Hiding assets in a bankruptcy is a serious wrong. The Texas two-step uses a trick of corporate law to hide assets in plain view with courts' connivance. I thank Senator Kennedy for his bipartisan approach to this hearing. I hope that we can continue to work in bipartisan fashion to address this abuse of our bankruptcy process and to make sure that injured victims get their day in court as our Constitution entitles them to. Senator Kennedy, you are recognized for your opening remarks.
Mr. Chairman, thank you for calling this hearing. Thanks to all of our witnesses for being here today. I look forward to their testimony, and I plan to listen and to learn. Thank you, Mr. Chairman.
All right, let us begin. Let us begin then with Judge Fitzgerald, a retired United States bankruptcy judge who served in the Western District of Pennsylvania from 1987 to 2013, including 5 years as the chief judge. While on the bench, she presided over more asbestos mass tort bankruptcy cases than any other bankruptcy judge. She is now a shareholder at the Pittsburgh-based law firm of Tucker Arensberg and a professor in the practice of law at the University of Pittsburgh School of Law, where she teaches courses in bankruptcy and advanced bankruptcy. Your Honor, thank you for being here. Please proceed with your statement.
Thank you, Chairman Whitehouse, Ranking Member Kennedy, and all of the members of the subcommittee. I appreciate the opportunity to be here today to testify as you continue your work on issues related to abusive bankruptcy and the impact of divisive mergers. And I appreciate the efforts that you are putting forth. I want to begin by noting that I see nothing improper with the state of Texas enacting a law authorizing a particular form of merger between companies or permitting the division of one company into two or more. Implementation of corporate law and policy customarily is a matter of state law. It is only when the corporate division separates out all of the troublesome liabilities into one company that I refer to as BADCO and puts the vast majority of the valuable assets into another company that I call GoodCo, and then BADCO files bankruptcy, but GoodCo does not, that the problems and possible abuse arise. I want to emphasize 3 points today that deal with the very essence of bankruptcy law. They are, first, bankruptcy relies on the good faith of the debtor to undergo a valid reorganization and to maximize the value of its assets and pay that value to creditors. 2, bankruptcy relies on the debtor's complete disclosure of all assets and liabilities. And 3, bankruptcy involves burdens and benefits which are intended to compensate creditors for what the debtor owes, in exchange for which the debtor can channel payments to a trust, discharge unpaid claims, and go about its business. First, the bankruptcy system relies on the good faith of debtors and requires that they utilize bankruptcy for valid reorganizational purposes and to maximize the returns they pay to their creditors. There is considerable concern today about the bona fides of solvent companies engaging in the Texas two-step for the sole purpose of sheltering their assets by putting BADCO into bankruptcy. It's important to note that a BADCO has no business to reorganize, and it is vested with insufficient assets to pay liabilities. Thus, the purposes of bankruptcy are not well served, and the good faith of a BADCO bankruptcy is called into question. Second, the bankruptcy system relies on full and complete disclosure so that all transactions take place subject to court and public scrutiny. Yet there is nothing in the bankruptcy code that requires GoodCo to disclose the assets it acquired through the divisive merger. Only BADCO, the debtor that absorbed the troublesome liabilities with insufficient assets to pay them, must disclose. Nonetheless, when BADCO files bankruptcy, it invokes the full panoply of benefits that it enjoys as a debtor and takes every effort it can to extend those benefits to its entire corporate chain and others, even though those non-debtors have not subjected themselves to court oversight. This enables the original tortfeasors to avoid accountability for the harms they caused. Third, there is another harmful impact, particularly on tort victims, when, in the bankruptcy process, they are left with recovering only from BADCO. This harm would not exist but for the divisive merger, because without the merger, if the original company filed bankruptcy, all of those assets and liabilities would be within the bankruptcy court's purview. The only purpose for which a BADCO bankruptcy is filed is to enable a solvent company allegedly responsible for injuring thousands of people to avoid litigating and proving its defenses in courts of law. The original solvent company uses Badco as a shield from disclosure, and then uses Badco's bankruptcy as a sword against tort victims who are denied billions of dollars in assets that otherwise would be available to pay valid claims. A Badco bankruptcy is not like other mass tort cases, where, for example, the asbestos manufacturer itself goes into bankruptcy, accepts responsibility, and negotiates a plan to pay tort victims. Badco bankruptcies are exactly the opposite. For example, J&J denies that its talc products were dangerous and caused thousands of women to develop ovarian cancer and mesothelioma, yet it formed LTL to act as its shield. In conclusion, I submit that Congress could find abuse of the bankruptcy system when the full benefits of bankruptcy are granted to a non-debtor, well-capitalized, solvent company, which, to avoid responsibility for its harmful conduct, manufactures Badco as a new company for the sole purpose of transferring the troublesome liabilities into it, and then hides behind Badco when it files bankruptcy. I thank you for this opportunity.
Thank you very much, Judge Fitzgerald. I appreciate it, and well done on the 5 minutes. I'm grateful to you. Our next witness is Professor David Skeel, the Samuel Arsht Professor of Corporate Law at the University of Pennsylvania, Carey Law School. We will get beyond Pennsylvania with other witnesses, I promise you. He is the author of numerous articles on bankruptcy and financial distress, corporate law, Christianity and law, law and literature, and other topics. Since August 2016, he has served on the Financial Oversight and Management Board for Puerto Rico, which he currently chairs. Professor Skeel.
Thank you very much. Thank you for the opportunity to testify today in this very, very important hearing that y'all are holding. It's, needless to say, a great honor to appear before you. The issue that we're focusing on today, the potential abuse of so-called Texas two-step transactions and other divisive mergers, is, in my view, one of the principal reasons for a growing backlash against perceived abuses in the Chapter 11 reorganization process. The term divisive or divisional merger is an oxymoron. Rather than combining firms, a divisive merger divides a firm's assets and/or its liabilities into two entities. In Texas two-step transactions, as in the controversial Johnson & Johnson case, the liabilities are shunted off into a new entity, and that new entity then files for bankruptcy. What this strategy is designed to do is to turn a company like Johnson & Johnson's consumer products business that would otherwise be liable into a third party, in a sense, and to obtain a giant third-party release, or what's sometimes called a non-debtor release. In a sense, what this is doing is manufacturing an opportunity for a non-debtor release. The opportunity for abuse and for undercutting the rights of victims and other creditors is obvious. One response to this is to rely on bankruptcy courts and bankruptcy judges to police abuses. Courts can dismiss a case if it was filed in bad faith, and in fact, a motion to do that is pending right now in the Johnson & Johnson transaction. And victims or other creditors can challenge the divisive merger as a fraudulent conveyance. Legislation was recently introduced in the House that would take a much more sweeping approach. The legislation would essentially bar the doors to bankruptcy for any divisive merger, whether or not it's abusive. I believe the better approach is to rely on the bankruptcy remedies rather than completely outlawing divisive mergers. Although the bankruptcy remedies are far from perfect, and I talk about some of the obstacles in my written testimony, in my view, they're adequate to the task. I could be wrong about this. Courts may fail to adequately police divisive mergers. If they do, legislative intervention can and would be warranted. But at this point, I don't think legislation is currently warranted, and I worry that any legislation might have unfortunate unintended consequences. So I guess my conclusion is divisive mergers really do create a danger of abuse. They should be scrutinized carefully and in appropriate cases kicked out of bankruptcy. But in the first instance, I would rely on the courts to do that policing. Thank you.
Thank you, Professor. Our next witness is Ms. Kimberly Naranjo, who comes to us from Sandy, Utah. She is a mom of 7, bravo, and prior to her mesothelioma diagnosis, she was a substance use disorder counselor with the Salt Lake County Sheriff's Department. Ms. Naranjo was also studying for a Bachelor of Science in Marriage and Family Studies from Brigham Young University, Idaho, prior to her diagnosis. She is a plaintiff in a talc lawsuit against Johnson & Johnson, and her claims have been stayed as part of Johnson & Johnson's bankruptcy filing. Ms. Naranjo, I'm very grateful that you took the trouble to travel here for this hearing in the situation in which you find yourself, so thank you. Please proceed.
Thank you, Chairman Whitehouse, Ranking Member Kennedy, and members of the subcommittee. My name is Kimberly Naranjo, and I'm here to ask you for your help in preserving my constitutional right and the rights of so many others to pursue accountability in our courts. I have been diagnosed with mesothelioma, which is a terminal cancer that's caused by one thing and one thing only: exposure to asbestos. I was given 12 to 16 months of life, which puts my expiration date at March 2023, 1 month before my 50th birthday. I'm a single mother with 2 of my 7 children still under the age of 18. Angelica, who is 14 and lives with a diagnosis of autism, and my son Jace, who's only 9. I would like to share my story with you. I was born into dysfunction. My biological mother was deep in her disease of addiction, and I experienced horrific abuse. I was in and out of foster care, passed around from family members, and on my own since I was 15. As a result of the trauma and abuse I experienced in my early years, family, being a good mother, and having stability was all I dreamed about. At the age of 19, I became pregnant with my eldest daughter, Maria, and then gave birth to 4 additional daughters, Adriana, Mona Lisa, Fabiola, and Karina, within the next 6 years. I wanted to be a good mom, something that I didn't have until my Aunt Kathy, who never gave up on me, took me in and later adopted me as an adult. She supported me my whole life and is right here behind me, supporting me now. Although I did my best as being a good mother, the unhealthy behavior patterns that I had been exposed to in my early years started to manifest in my life. I needed to do something to stop the cycle. My adopted mom permanently took over caring for my 5 children, and I attended a residential program where I lived for 13 months. I'm proud to say that next month I will celebrate 15 years of sobriety. After completing treatment, I gained enough skills to become a productive member of society. I decided that I wanted to get an education and dedicate the rest of my life helping others overcome their hardships. I graduated with highest honors with my associate's degree in alcohol and drug counseling, and I started working as an addiction counselor. I've dedicated the last 7 years of my life helping and advocating for others. I didn't want to stop there. I continued my education at BYU, Idaho, working towards a bachelor's degree in marriage and family studies. My goal was to get my master's degree in social work. I've worked very hard to break the cycle for my children, who I'm blessed to have a wonderful relationship with today. Since my disease of addiction has been in remission, I have been an active and supporting participant in all their lives. Throughout my life, I've never lived in one residence longer than 2 years, and I wanted that to change. So last year, I purchased my first home, my forever home. I was also hired at my dream job working for the Salt Lake County Sheriff's Office as an addiction counselor. 3 days into working at the Sheriff's Department, I felt a pain in my side. The next week, I was diagnosed with mesothelioma. It all happened so fast. 1 week, I was enjoying my forever home, surrounded and celebrating life with my family. The next week, I was given an aggressive treatment plan in hopes to extend my life by a few months. Unfortunately, I was no longer able to work. With no income, I was unable to pay my mortgage and forced to sell my forever home. I then had to sit down with my children and grandchildren to let them know that I'm going to be leaving my body. That was a really hard day. My oldest daughter, Marie, is only 28 and a single mother, and she is going to raise my 2 children after my death. After spending hours going over every place I've ever lived or worked, it was determined that the only way I was exposed to asbestos was from Johnson & Johnson's baby powder. Instead of protecting my children as advertised by Johnson & Johnson, I had no idea I was exposing them and myself to the deadly asbestos that in that white plastic bottle that I associated with motherly love. When I learned that I could file a lawsuit and have it decided by a jury, I saw a path forward for my family. There was a way that my children could be taken care of monetarily as if I had lived. I was less scared knowing that even though I can't control the fact that I'm dying, I could use my constitutional right and be heard in a court of law. I knew that justice would take care of my family. I was filled with hope. That hope was also taken from me. I learned that Johnson & Johnson filed for bankruptcy and that I would not receive a court date. I didn't understand. Johnson & Johnson is a really big and thriving company. How can they be bankrupt? I learned that they took advantage of a loophole where they made a new company and put all their responsibilities related to Johnson & Johnson's baby powder into that company, then file bankruptcy. And now everything's stopped, except for the progression of my cancer. I've accepted the fact that I don't have much time left. I even held a living memorial where I gave all my friends an opportunity to say goodbye. I made parting gifts. When I graduated from residential treatment, I was given a poem, as you can see right there. It's framed, it's "Don't Quit." That's my motto. I made copies of that picture, little wallet size, and handed them out to all of my friends, everybody who came and celebrated my life with me. I don't have much time left, but I will not quit. Even though I'm in pain every day, I get up and do my best to make a difference in the world. I've even made myself a stickers chore chart. And I give myself a star for getting up, taking a shower, walking my son to the bus stop, and cooking. I will not quit no matter how tough this gets. It took every ounce of strength for me to be here before you today, but I am here because I am a voice for the thousands of people that Johnson & Johnson have harmed, and we have a right to be heard. I'm so grateful that you've listened to me. I wish that Johnson & Johnson would listen too, but they took that right away from me and thousands of other people who have their own stories, families, and lives that also deserve a right to be heard by a jury. Thank you again for your time and attention. I am truly grateful.
Thank you, Ms. Naranjo. We do hear you, and we will remember. Paul Zumbro is a partner at Cravath, Swain & Moore and the head of Cravath's Financial Restructuring and Reorganization Practice. Mr. Zumbro's practice focuses on restructuring transactions and related financings, both in and out of court, as well as bankruptcy, merger, and acquisition transaction. His restructuring experience includes both debtor and creditor side representations and includes work in the fields of municipal and sovereign debt restructuring, as well as insolvency-related litigation matters. Mr. Zumbro.
Good afternoon, Chairman Whitehouse, Ranking Member Kennedy, and subcommittee members. I'm honored to appear before you today to discuss divisional merger bankruptcies, known more colloquially and colorfully as the Texas two-step. I'm testifying today solely as an expert in the field and not on behalf of any person or party. Texas two-step has a lighthearted ring to it, but the underlying issues are serious and important, and I commend the committee for examining the topic. My perspective as a bankruptcy practitioner is this: divisional merger bankruptcies of the type that have been filed are an appropriate use of bankruptcy. Before discussing the reasons for that conclusion, let me first briefly describe what a divisional merger is. 2 states have enacted divisional merger statutes, Delaware and Texas. Unlike a traditional merger where 2 entities merge together to form a new entity, a divisional merger involves one entity dividing into 2. In a divisional merger bankruptcy, the original company is divided into two parts. One new company that attempts to resolve the asbestos-related claims globally through a Chapter 11 bankruptcy process, and one new company that continues to operate the business. Here is where a critical misunderstanding may arise. While the transaction involves two steps, the separation of entities and a bankruptcy filing, it does not involve the sidestepping of accountability or financial responsibility for the asbestos-related claims. The law should not and would not allow that. Going all the way back to the Fraudulent Conveyances Act of 1571, also known as the Statute of 13 Elizabeth, it has been illegal to take actions with the purpose and intent to delay, hinder, or defraud creditors. Those same words appear in our federal bankruptcy code and in the laws of all 50 U.S. states. Importantly, the Delaware and Texas divisional merger statutes do not attempt to override this longstanding body of law. Rather, both provide that any division of assets and liabilities is subject to existing creditors' rights laws. The reason these transactions should not constitute a violation of creditors' rights laws is the funding agreement, an agreement from the operating company to fund the trust to be established under Section 524G of the Bankruptcy Code to pay the claims. There is a funding agreement in each of the divisional merger bankruptcies filed to date. At the core, the funding agreement evidences an affirmative acceptance of financial responsibility and access to the value of the company that existed pre-separation, not a corporate effort to sidestep accountability. So why split the company before bankruptcy? Because it allows the company to use the tools contained in the Bankruptcy Code, such as 524G trust, to address mass tort liabilities and compensate claimants while preserving as much value as possible for all constituents. By separating the company into two, productive assets and businesses, which often have operations separate from the operations that result in the potential liabilities, will be able to operate without the overhang of bankruptcy, which, among other things, affects employee retention and relations and relationships with suppliers and customers. That value inures to the benefit of the claim holders through the funding agreement, so that the claim holders are no worse off and they may be better off. It also enables the company to use the Bankruptcy Code to address tort liabilities in a way that is more streamlined and is fair to the claim holders more fair to the claim holders as a whole than the tort system, through the use of provisions like the Section 524G of the Bankruptcy Code. Claimant trusts have been an accepted method of addressing asbestos claims since at least 1994, when Congress added Section 524G to the Bankruptcy Code. They are fair. They can only be established if 75% of the claimants themselves approve it. They are efficient. Bankruptcy provides a single, centralized forum to resolve and pay claims, and they are equitable. Unlike the lottery-like results of a pot of gold for some claimants and little or nothing to others, that is not allowed in bankruptcy. Both for these reasons and the strong federal policy of access to bankruptcy, I do not believe the legislation that has been proposed to outlaw a bankruptcy filing within 10 years of a divisional merger is necessary or appropriate. In my opinion, congressional time and effort would be better spent on other bankruptcy topics, such as establishing uniform standards for third-party releases in appropriate cases. Mr. Chairman, I thank you again for the opportunity to share my thoughts on these very important issues.
Thank you. Our final witness on the panel is Mr. Kevin Maclay. He is the head of the Bankruptcy and Complex Litigation Practice Groups and a member of the Board of Directors at Kaplan and Drysdale. Mr. Maclay's practice focuses on complex civil and commercial litigation and protecting creditors' rights in Chapter 11 bankruptcy cases. Mr. Maclay has extensive experience in such representations, including serving as co-lead bankruptcy counsel in the DBMP, and Aldrich Pump divisive merger bankruptcies. Mr. Maclay.
I would like to thank Chairman Whitehouse, Ranking Member Kennedy, and members of the subcommittee for inviting me to testify here today. My name is Kevin Maclay, and I'm here to talk about the Texas two-step. The Texas two-step is, at its core, extremely simple. A company splits into two entities. One of those entities gets nearly all of the assets and whatever liabilities the company decides it wants to keep paying. The second company is a mere shell. It gets almost none of the assets, but gets whatever liabilities the company chooses to stop paying. To date, those disfavored liabilities have been those owed to tort victims, like Ms. Naranjo sitting one chair over to my right and from whom you've just heard. Then the shell company files for bankruptcy protection. This immediately cuts off Ms. Naranjo's ability to get paid for her injuries, potentially for an extended period of time, while other creditors of the original entity continue getting paid in full and on time. Indeed, from the perspective of the non-bankrupt company, almost nothing has changed because that entity carries out business as usual under the same name as the original company, making the same products as the original company, and selling to the same customers as the original company. Yet, because of its artificial creation of a bankrupt shell company through the Texas two-step, the non-bankrupt is both immune from suit in the tort system and free from the bankruptcy court oversight and transparency required of all debtors in the bankruptcy system. No one should be able to put themselves above the law this way. And until 2017, no one had. But then Georgia Pacific pioneered the Texas two-step. As a result, the tort creditors consigned to its bankrupt shell company, Bestwell, have been stuck in bankruptcy for more than 4 years now without being paid a dime, while all other creditors have been paid in full. Since then, the dominoes have continued to fall as one extremely wealthy corporate family after another, all of them worth many billions of dollars, have used the Texas two-step. Certainteed and Saint-Gobain, Train Technologies, and now even Johnson & Johnson. Johnson & Johnson is worth more than $450 billion, and its credit rating is higher than the U.S. government's. Bankruptcy is intended to assist the honest but unfortunate debtors seeking to reorganize. When the richest and most powerful corporations in the country are using the federal bankruptcy system to avoid paying the most vulnerable people in the country, something is wrong. The system needs to be fixed. The Texas divisional merger law was never intended to be used this way. It explicitly was intended to preserve all rights of creditors under existing laws. But out-of-state companies have misused that law to pervert the federal bankruptcy system. And this is just the beginning. While the Texas two-step so far has been used to disadvantage tort victims, the very same mechanism can and inevitably will be used to permit corporations to rid themselves of any unwanted creditors, commercial and contract creditors, warranty claim creditors, environmental creditors, or others. The Texas two-step is a free pass for a corporation to disregard its obligations under the law at will, and I believe that Congress should act now to close this loophole. Now, you've heard today about the so-called funding agreements. Well, let's talk about funding agreements. First of all, they're written by the same people who came up with the Texas two-step. They're not a protection against the Texas two-step. They're part of the scheme. First of all, they don't prevent the non-bankrupt entities from sending their cash, potentially all of their money, to other entities. They don't prevent subsequent mergers or acquisitions. And most importantly, the non-bankrupt entities that control the bankrupt shell companies have the final say in whether those bankrupt entities even ask for the funding agreement to be complied with in the first place. In other words, these are highly contingent and frankly illusory agreements, which are not a protection against anything. Well, we've heard about other existing remedies. Well, look, the other existing remedies haven't stopped the Texas two-step. More and more of the richest companies in our country are doing it, and their victims are getting stuck in bankruptcy indefinitely, which deprives them of their ability to seek justice in this country, which allows all other creditors to be paid. It's just not fair. We have already heard about in the Bestwell bankruptcy, 4 years later, they're still stuck in bankruptcy. That's not even-handed justice. And frankly, members of this subcommittee, delay is the point. This mechanism is used to stick disfavored creditors into a bankruptcy where they're stuck in the hopes that someday they'll knuckle under and agree to just accept pennies on the dollars for the values of their claims. The existing bankruptcy code has not been sufficient to stop this scheme. It's only accelerating. And unless the subcommittee and Congress does something to stop it, I fear it's only going to get worse. Thank you.
Thank you very much. Judge Fitzgerald, to go to your good co, bad co example, when the division takes place, how does anyone know that all of the injured parties have been found yet? How does one know the scope of the total injury that has been inflicted?
I don't think they do know that, Senator. What they know is the number of suits that have been filed against them and/or complaints that have somehow come to their attention, not necessarily formal complaints. In all of these cases, there are huge numbers of future demands, which is one of the reasons that Congress foresaw the need for Section 524G. So I don't think it's possible to know.
And what happens to lawful claims for punitive damages?
Well, that depends on the particular case. In the Bankruptcy Code, punitive damages are generally subordinated to other types of claims. It depends on the state law, what has happened in many of the mass tort bankruptcy cases.
What happens if the total injury exceeds the trust amount? Does Badco have a continuing claim against assets of Goodco to fill in any gaps?
That depends, Senator, again, on what the relationship between the parties is. In the case of the funding agreements, the assertions have been made that that's the case, but in fact there are cross indemnities, generally speaking, such that if Badco pays out money, then Goodco is supposed to reimburse, but if Goodco pays out money, Badco is supposed to reimburse. So the net effect is not necessarily clear, first of all. And
Is
secondly,
Goodco a party in the bankruptcy proceeding?
I'm sorry?
Is Goodco ordinarily a party in the bankruptcy proceeding?
No, it's not a party unless it has co-liability with the debtor. To that extent, it is essentially a party. It's a named party. But the problem is that Goodco usually has independent, or the allegations are that Goodco has independent liability, which would not be part of the bankruptcy estate.
And how about evidence, discovery, corporate documents, things like that? When somebody's been injured by a corporate entity, usually there's a very robust discovery. That discovery can continue really until the eve of trial on some occasions. And I'm familiar with times when documents have been discovered that completely change the complexion of the liability. When Ms. Naranjo is sent to Badco, what rights does she have and what rights do her lawyers have to continue discovery and document production and so forth against Goodco?
Well, they still have rights. The problem is that the way the operation has worked in bankruptcy is that those rights are stayed and generally temporarily, if not permanently, enjoined. And so although there may be rights to discovery, they're not accessible. The system simply is not sufficient in that respect to deal with those issues.
So discovery effectively stops
Yes.
at when the Texas two-step begins.
Well, it stops as to Goodco.
Yes.
Yes,
And there's no reason for Goodco to turn over all of its documents to Badco, is there?
certainly not.
In fact, that would be counter to the purpose of the operation, assuming the purpose of the operation is to protect the assets of Goodco.
That would be my opinion, yes, sir.
Mr. Maclay, do you have any response to any of those comments that I just made? I've got another minute before I turn it over to Senator Kennedy.
Yes, Mr. Chairman, I think you've made an excellent point and suggested an excellent point, which is that Goodco isn't a bankrupt. It's not supposed to get the protections of the bankruptcy, but it gets to enjoy those protections at the same time as, like a puppet on a string, it controls Badco. Because Badco has overlapping officers and directors with Goodco and the rest of the corporate family. It's really just an illusion, Your Honor, to think of Badco as anything other than an empty shell, as even some of the courts applying these bankruptcies have recognized.
Makes one think of the old doctrine of piercing the corporate veil. Would
You're
that apply
exactly,
here?
you're exactly right, Your Honor, not Your Honor, excuse me, Mr. Chairman.
It's all right.
That, you can tell I'm a lawyer, that there are supposedly remedies that will work, but what we're talking here about time. People don't have 10 years to wait for all of this to play out. People are dying now, people need to get paid now, and ultimately this is all about delay. That's the whole point. And so justice delayed is justice denied, Mr. Chairman.
Senator Kennedy.
Thank you, Mr. Chairman. Ms. Naranjo, did I say your name right? I'm sorry for all
Yes,
your
you
trouble.
did. Thank you.
I'm sorry for all your troubles.
Thank you.
Mr. Zumbro, tell my old friend Phil Gelston I said hi.
Yes, sir, I will do so.
Very,
He had warm regards to send to you as
well,
well.
fine lawyer, fine lawyer. Professor Skeel, with respect to a divisional merger and then a bankruptcy, does the bankruptcy judge or does the bankruptcy court make a distinction between a divisional merger bankruptcy in good faith and one in bad faith?
Yes, I think a bankruptcy judge would. I think they would look at the bad co, to use the term that we've adopted from Judge Fitzgerald. They'd look at bad co and they'd ask the question, is that an entity that is in bankruptcy for a proper bankruptcy purpose? And if you set up a bad co that had real assets in it and it had the liabilities as well, you might say yes, that's a proper purpose for that for that entity. But the judge looks at what went on in the particular divisional merger and makes a decision.
Let me explore that a minute. I've not ever practiced in bankruptcy court. When a divisional merger is done, and then there's a bankruptcy, and you have two companies, I'll use the terms rich co and poor co, as opposed to good and bad. Does the bankruptcy, I assume that counsel for the creditors is raising fresh hell and saying this divisional merger was in bad faith and it was only done to avoid liabilities. Assume that's one of the allegations. Does the bankruptcy judge then hold a hearing and look to poor co and its present and prior management and say, tell me why you did this divisional merger? And if they say to avoid our liabilities, does the bankruptcy judge then have authority to say, no, get out of my courtroom?
The answer to that would be yes. I'll unpack it just a little bit if I can. So you do the divisional merger. There's nothing strange about a divisional merger in concept. I mean, you can have perfectly appropriate divisional mergers and nobody thinks about it until we end up in bankruptcy. But if you do a divisional merger and then you put bad co or poor co into bankruptcy, and the creditors, the victims, challenge the bankruptcy, say it was filed in bad faith, then the bankruptcy judge assesses the divisional merger, the Texas two-step, and determines whether it belongs in bankruptcy or not. And the standards that courts use vary a little bit from court to court. But the standard that will apply in Johnson & Johnson, for instance, which is the Third Circuit standard, the Court of Appeals for the Third Circuit, what the court will ask is, was there a valid bankruptcy purpose? That was the first question. And then the second question is, was this bankruptcy filed simply to gain a tactical advantage in litigation? And if it's not a valid bankruptcy purpose or it was solely for a tactical advantage, the court will kick the case out. And there is a hearing in Johnson & Johnson in its divisional merger case next week to address that question.
Let me ask Mr. Zumbro. It seems to me that the issue is do we have a prophylactic rule passed by Congress that says you can't do a divisional merger and then a bankruptcy? Or do we rely on the bankruptcy judge to decide when a divisional merger is in good faith and bad faith? Bad faith meaning to avoid your creditors.
Senator, I think that's right. I think the bankruptcy courts are much better positioned to evaluate those issues than Congress. I don't think a law that flatly prohibits a bankruptcy filing after a divisional merger is appropriate or necessary. I did a divisional merger recently for a media company that needed to sell a content library. So if that company that bought the content library needs to seek bankruptcy protection in 10 years, why should it be precluded from doing so? I think the courts can make these determinations on a case-by-case basis.
I understand. Could I ask, Mr. Chairman, for 30 more seconds, could you weigh in on that, Mr. Maclay?
Absolutely. First of all, what Mr. Skeel said, what Professor Skeel said, is not accurate in the Fourth Circuit. In the Fourth Circuit, where these bankruptcies are all originally filed, bad faith is not enough to dismiss the bankruptcy. A judge could find it's in complete bad faith, it's a scheme, it's a fraud, but yet if the defendant, if the debtor can argue there's a reasonable likelihood of a successful reorganization, a standard which is almost impossible to meet, then the bankruptcy has to stay. So dismissal is not an adequate remedy, even for bad faith under the law of the Fourth Circuit, where they, of course, file. Secondly, with respect to this prophylactic rule, think about the implications of what I've just said. The court's hands are bound. They're bound by this governing, controlling precedent, and it doesn't matter if it's bad faith. That's not enough. Judges are, of course, faced with the cases in front of them, and they do their best, faced with the cases in front of them. But when there was such a widely used scheme where the wealthiest corporations go into bankruptcy to disadvantage some of their disfavored creditors, that is a universal problem that I would submit calls for a universal answer.
Okay. Thank you all. Mr. Chairman, I have been asked by Professor Anthony Casey of the University of Chicago Law School and Professor Parikh of the Lewis and Clark Law School to offer statements on their behalf into the record. I haven't.
Without objection, they'll be made part of the record.
Thank you. I'm sorry to go over, Mr. Chair.
Nope, not a problem. Senator Hirono.
Thank you. I do not know if these questions have been asked, but it seems to me that, especially in the Fourth Circuit, there is a giant, I don't know what, I would call it a loophole. Mr. McCauley, you refer to that? For plaintiffs to get any kind of redress. So this is pretty elementary, I suppose, for people who practice in that area, but I'm not familiar with bankruptcy practice. But if there is this kind of divisive restructuring and the assets are in good co and the bad co is the one that files for bankruptcy, I don't understand why why can't the plaintiffs just turn around and sue good co? I think this must be a question for our first witness. Professor?
Senator, what happens
Or Judge Fitzgerald,
I'm sorry.
Go ahead, it's for you.
What happens, Senator, thank you, is that Badco files bankruptcy and has the benefit of the automatic stay, which stops all litigation against the debtor. In some courts, including those in the Fourth Circuit that have been looking into these divisional mergers, that automatic stay has been extended to parties that are not the debtor. So it's extended to good co, and it's extended to, in the Third Circuit right now, to Johnson & Johnson. Now, at the moment, as to Johnson & Johnson, it's on a temporary basis. The court has not ruled yet on a permanent basis. But nonetheless, in the other cases, some of which have been pending for 4 years, tort victims have not been able to pursue their claims against any other company in the corporate chain because the courts have extended the automatic stay and or issued injunctions prohibiting that action from going forth.
See, that's the part that I don't understand. Why should there be an automatic stay when using this kind of a process, but basically a company can hide its assets, but literally in your face? So I don't understand why in bankruptcy law there is this automatic stay and the plaintiffs cannot get to the company that actually did the harm but they are insulated. Why is there this automatic stay? Anybody else can weigh in and
The stay is sometimes extended to parties who are co-liable with the debtor because, for example, they may share insurance. And if the automatic stay is not extended to a party that shares insurance with the debtor, and all of that insurance is depleted for other claims that are directly against that other estate, but not against the debtor, then the debtor's estate is diminished. So there are reasons why the stay may actually be validly employed against other companies. But the problem that these companies are facing, that the tort victims are facing, is that the stay is stopping all action. So Johnson & Johnson, for example, can go on its merry way without anybody suing it for its direct liability that's totally unrelated to its co-liability. There are different theories and causes of action that can be brought by parties. And
Is the stay a result of judicial action, or is there some law that says in bankruptcy filings there will be an automatic stay?
no, the stay is extended to parties when the debtor files a motion and or an adversary proceeding and asks the court to extend that stay, except in Johnson & Johnson's case, the debtor, LTL Management, notified all of the tort cases in which it was involved before it went to court and asked the judge to extend the stay, that the stay applied to JJCI and J&J.
So that really sounds like an abuse of process to basically stop plaintiffs at the courthouse door. And so what if we consider legislation that will prevent in these kinds of situations from any kind of a stay that completely insulates good co?
One of my colleagues used to say that you don't kill a flea with an atom bomb. And so I think the unintended consequences may be something that Congress might want to look at, because certainly...
Okay, I'm sorry. I understand about unintended consequences. Do you have any suggestions? Do any of you have suggestions to close some of these, to prevent these kinds of what I would call abuse? And also, if it's relatively easy to engage in these kinds of divisive mergers, what is to prevent a company from just creating those kinds of entities at the very beginning and just hold the Badco in abeyance until there's time for when Badco should file for bankruptcy? Why don't all companies engage in these kinds of mergers to insulate itself?
If I can
please.
say a few words, you don't need to, in a way. I mean, you don't need to set this up today, because as Johnson & Johnson did, you can do it at the last minute. I mean, you can do it, and it takes a day to do this, so there's no need to do it in advance.
Well, that's the answer to that question. So, Mr. Chairman, I'm glad you're having this hearing because I'm learning something about bankruptcy law. And I think we need to do something, but we will, I hope
We
you
will
can come up
pursue.
with, I hope you can come up with something.
We will pursue.
Okay.
And
Thank
we
you very
are
much.
very honored to be joined by the chairman of the full Judiciary Committee, Senator Durbin of Illinois, and I recognize him now.
Thanks, Senator Whitehouse. 26 years ago, I walked into this very room to become a brand new member of the Senate Judiciary Committee. I was appointed to this subcommittee, and the chair was a man named Chuck Grassley. And we were doing something that was interesting. We were rewriting the bankruptcy code. You may remember that 26 years ago. Well, it turned out I was the resident expert on the bankruptcy code by virtue of taking a course in bankruptcy at Georgetown Law School and having been appointed a trustee in bankruptcy for a gas station in Springfield, Illinois, by Judge Basil Kutrikan. I had more experience with bankruptcy than anyone on the committee by virtue of those two things. And we set about writing the code, and Chuck Grassley taught me a lot about bankruptcy. He's a pretty smart fellow. So I've tried to understand it going forward and tried to put aside all the wording of bankruptcy, which can be dry as dust, to get down to the human side. Ms. Naranjo, you helped us understand the human side in a very personal way, and I know it took its toll on you emotionally, but thank you for being here. It makes a difference. So I listened to your explanation, Mr. Zumbro, rationalization of divisional merger. And there was one sentence you used, I went back to make sure I caught it. And you said, why would a company do this? And you said, by separating the company into two productive assets and businesses will be able to operate without the overhang of bankruptcy, which among other things affects employees' retention and relationships with suppliers and customers. I think it might also be about money. Just going on a limb here. It isn't just a matter of getting along with people. There's a lot of money on the table. For instance, LTL Management has $2 billion in its settlement fund. That's the poor co or bad co, depending on how you want to characterize it. $2 billion. Huge, right? Not really. In one talc case against Johnson & Johnson involving 22 cancer victims, plaintiffs were awarded a judgment of more than $2 billion. How would you evaluate the legitimacy of Johnson & Johnson's claim that their actions will actually benefit the 38,000 plaintiffs like Ms. Naranjo who are seeking restitution?
Well, sir, I think that the bankruptcy system is supposed to be fair and equitable to everybody. As I mentioned in my testimony, the pot of gold for that $2 billion verdict might mean someone else gets zero in a verdict and gets nothing. So what the bankruptcy process is meant to do, you can't do that. You can't have one person getting $2 billion and one person getting nothing in the bankruptcy process because that's not permitted. So it's fair and equitable to everybody because everybody has to get treated the same in bankruptcy.
You missed something very critical. The good co, if you can call Johnson & Johnson that, is worth $430 billion. So the bad co, LTL, ends up with $2 billion for 38,000 claims. And you're saying that is a fair apportionment by Johnson & Johnson? Get real. The idea was to protect $430 billion worth of corporate assets by creating a $2 billion entity. That you think is fair because it's so small.
Sir, what I'm saying is, I don't even know if I can do the math, but whatever $2 billion is times 38,000, that's bigger than even Johnson & Johnson could pay, right? Johnson & Johnson is a lot more than, and I'm not representing Johnson & Johnson, but they're a lot more than just the talc. They've done COVID vaccines. They do a lot of other medical things that are very valuable. And Johnson & Johnson is not a monolithic corporate entity. It's owned by pension funds. It's owned by regular Americans in 401k. So this is a more nuanced issue. Yes, it's about saving money because the tort system is broken and you can't resolve 38,000 claims in the tort system. The bankruptcy system allows it to be done more efficiently.
Mr. Zumbro,
it's a win-win for both the companies and the victims.
Our legal system is supposed to be looking for justice, not efficiency. And if you think efficiency says a $430 billion corporation can walk away from any wrongdoing, I don't know when or if they ever discovered asbestos in talc, which may have led to the mesothelioma suffered by the gentlelady sitting to your right. But at some point, they're going to be asked that in court and held responsible for their answer. And apparently, they're losing these cases. So there could have easily been some knowledge, or there should have been some knowledge, that they were, in fact, selling a dangerous product which endangered the life of their innocent customers. Go to Johnson & Johnson's website and take a look at all the pictures of those beautiful babies and all the products they sold for those babies. Our family bought some. Bet you everybody in the room did too. Never thinking for a moment that it might be dangerous. It turns out it was dangerous, and people are suffering injuries, and they are trying to dance around the bankruptcy system to avoid paying these innocent victims. That is not good corporate responsibility. I yield.
Senator Blumenthal.
Thanks, Chairman. I apologize that I was absent for part of the testimony because I had to go vote, so forgive me if I'm repeating any of the ground that's covered, but I first want to just second what Chairman Durbin has just said about the purpose of the whole justice system. It is to enable the survivors and victims of harms to have a fair day in court and to have fair access to compensation that they're entitled to receive. And I want to focus on one aspect of the bankruptcy system that so deeply troubles me. What we're hearing about the use of the Texas two-step rule, as it's known, to borrow your phrase, Mr. Zumbro, colloquially and colorfully, is very, very serious, which is the choice of venues. Now, I recognize that some districts, like the Southern District of New York and the Eastern District of Virginia, which until recently saw a lot of venue and judge shopping, have taken some steps toward self-correction by requiring random judge assignment in bankruptcy cases. Some individual judges have stepped up as well, like Judge Whitney, who transferred the Johnson & Johnson bankruptcy from North Carolina to New Jersey, where Johnson & Johnson is actually headquartered. But we've seen companies move their headquarters to take advantage of supposedly favorable forums and judges. And there's a whole cottage industry that is favorable to one side or another side. And a lot of the parties are not only skeptical, they are utterly cynical about how this system works, non-lawyers as well as lawyers. I've been very proud to work with Chairman Durbin and Senator Warren on our Non-Debtor Release Prohibition Act to close some of the loopholes that enable these kinds of judge shopping problems. So I'd like to ask all of you, aren't you troubled by it, and what should we do about it?
Thank you, Senator Kevin Maclay. I think really the venue issue is part of the broader problem that we're here talking about today, which is corporations planning out how to disadvantage their victims, essentially, their creditors, and the fact that they have filed in the Fourth Circuit and in the Western District of North Carolina. Only they can tell you for sure their subjective reasons for doing so, but of course the effect of it is that bad faith bankruptcy filings can stay around and be used to disadvantage their victims. And it's just one example, Senator, of a facet of the problem that hopefully Congress will be able to fix, because it's a very real problem. And I don't know, one of the questions was asked earlier, why doesn't everyone do this? Well, given the way the law is currently being applied, I don't know why everyone doesn't do it. You get to stick all your liabilities into bankruptcy and keep all your operating companies out, not even the inconvenience associated with the bankruptcy. It's really a major, major problem. It's a loophole that could swallow the entire bankruptcy code. I view it as a problem that needs an urgent and immediate solution.
And no matter how good the rules, and I'm probably one of the few United States senators, at least in office today, who has actually tried a bankruptcy case, which I did as state attorney general. I tried a bunch of cases, as did some of my colleagues. I'm no bankruptcy expert, and that's my point, that the bankruptcy system is a set of seemingly abstruse, arcane rules that has a separate set of practitioners and a separate judicial system. And if you're Purdue Pharma and you go to White Plains, you got a judge that, and I'm not drawing any conclusions here, but according to the plaintiffs, in separate actions, the state attorneys general and some of the victims and survivors was very favorably inclined toward Purdue Pharma and the Sacklers. And likewise, that pattern repeated. So I guess I'm honing down on reforming the rules, but making sure the rules are applied even-handedly and fairly. Mr. Zumbro?
Senator, first, thank you for the question. I do think I would respectfully disagree on the Non-Debtor Prohibition Act. I think a blanket prohibition is not the right way to do it, but I would encourage Congress to consider adopting more uniform standards for when it is appropriate, because that issue, like the issue we discussed today, I think is more nuanced and less black and white than it might seem, because I think there can be appropriate circumstances where the victims can actually recover more than they would have otherwise recovered as a result of that. But I do understand your concerns about venue. I think having the notion that third-party releases are illegal in California, they're illegal in Texas, but they're permitted in Delaware, maybe they're permitted in New York, I think they should be, is probably not the right way, because our Constitution requires Congress to enact uniform laws on the subject of bankruptcy. So I would encourage the Congress to consider uniform standards for that. But as I've recently written on behalf of the New York City Bar Association, we've written a letter to you and your colleagues explaining the reasons why we don't think an absolute prohibition is the right way to go, but rather more standards that are uniformly applied across the judicial circuits.
Anyone else? Ms. Naranjo or?
Yes, thank you so much,
Skeel.
Senator. What I would like to see is I would like to have mine and the other 38,000 victims that are known as of right now. Just mesothelioma takes about 30 to 50 years to even show up. There's going to be more victims. I want to have my constitutional right to be heard by people who harmed me, who harmed my children, who harmed my family. I just want to be heard. And that right was taken away from me.
And thank you for being here today.
Thank you for listening.
Professor?
I would just say that I do think there's some venue issues. I think the important thing is to address the problems and not pass anything that fixes things that aren't problems or changes things that aren't problems. In my view, the two big problems we have now, one is judge shopping, which you alluded to in White Plains and Houston, Texas, and the Eastern District of Virginia. That seems to be in the process of being solved, at least in the short run. But parties should not be able to pick judges within a district, so that's a problem. The other problem, in my view, is the affiliate part of the venue provision, which says if a connected entity, an affiliate entity, has filed in a courthouse, you can bring the rest of the entity in, even if it's some tiny little entity that just got formed for the purposes of the bankruptcy filing. That's a problem, in my view. And a venue reform that addressed that, I think could help. What I don't think would help would be to take away the domicile venue option, which is the Delaware venue option. I do think that firms ought to be able to file in their state of incorporation. And so, in my view, it's very important to solve the problems and not create problems by taking away options that really aren't the problem. The real problem, in my view, is judge shopping and that affiliate hook, which people have used to do outrageous things.
And part of the problem is, as Mr. Zumbro observed, that these rules can differ from one state, one district to another.
Exactly, and bankruptcy lawyers will tell you quite candidly that they have a conversation about that when they're about to file a bankruptcy case. They feel like it would be malpractice not to consider the fact that the third-party release, the non-debtor release law is very different in New York than it is in Delaware than it is in Chicago. Or
good
Texas.
Argument for maybe a non-debtor release national rule, which I proposed in the Sackler Act.
Possibly, although I am of the view that it's important that it be nuanced, I think it would be a mistake to completely outlaw third-party releases, but cracking down on them I think makes sense, and there is an argument for just getting rid of them. And the basic argument is, if you don't file for bankruptcy, you don't get the benefits of bankruptcy. What third-party releases are doing is giving the benefits of bankruptcy to folks who don't file.
Right.
There's a counter-argument, which is, in some cases, bringing it into the bankruptcy context and is better for everybody, but that's not always true.
Judge
If I
Fitzgerald.
may take the chairman's prerogative here, I would like to ask Ms. Naranjo for a last word here, because one term that has come up repeatedly in this hearing has been time. And there is no better witness on this panel as to the matter of time than you. In addition to what time you have remaining, you also have decisions to make with regard to what you can leave to and how you can provide for your children. And presumably without knowing what is going to emerge from this black hole of a bankruptcy that you are stuck in, those decisions are hard to make. And time is short for you to make those decisions. If you could close us out with a few words about time.
Yes, time is something that I think folks take for granted. We sometimes feel, we have time, we can get to that, this will happen. Something that I've heard said today was, to make it fair and even. That bankruptcies can do that. I won't be here. My kids will probably be 18 by then, because it takes a long time. I am scared for my family. Like I said in my testimony, my daughter's only 28. She's a single mom. She doesn't own a home. She's a hairdresser. She's going to raise my children. I don't have a pension. I don't have a 401k. I started late in life, but when I started, I took off running. I would like more time. I don't have time. 38,000 other people need more time. But we don't know how much time we have in life. It needs to be heard. It needs to be heard now, not later. Now I'm scared. I don't know what's going to happen. I am so excited to be here today.
Would you do me one favor? Would you tell your daughter, Mona Lisa, that my chief of staff is also named Mona Lisa?
I heard that. Such a rare name. Such a rare name. And I'm so happy to be here. My family's so happy that I was invited here. And I am so grateful that I got to be heard.
We're delighted to have you here. The record of the hearing will stay open for 1 week. So any further comments can be included. I don't believe we had any questions for the record, but if there were any, please answer within the week. And we will undertake to try to figure out something fair here. It does not make sense for a $450 million corporation with 38,000 people with potentially lethal injuries to be able to carve off $2 billion. I did the math, Mr. Zumbro. It's about $52,000 per person. And walk away from the responsibility for what it did. And with respect to the questions of fairness and efficiency, there's a larger scope for fairness here in which it looks like big companies are getting away with dodging real responsibilities by using complicated trickery that ordinary people don't have access to, with the result that they create delays that cause people like Mr. Ano to get actually no recovery in her lifetime. So that's neither efficient nor fair. I hope we can find a sensible way to solve this. Thank you all for your testimony. It's been very helpful.